The defense immediately signals they're unprepared, lacking even the basic police reports, which already raises eyebrows. The judge doesn't waste time, pressing for a date while balancing the court's schedule. There's a subtle tension here, justice delayed versus fairness ensured. Within seconds, a decision is made, and the case is pushed forward. It's quick, procedural, but crucial. This opening sets the tone perfectly, showing how swiftly legal decisions can shape the direction of a case before it even begins.
Your Honor, I was just retained in this matter yesterday. I don't even have the police reports yet, so we're asking for an adjournment to the 30th.
You want the 30th or 23rd?
The next 2 weeks I'm on trial, Your Honor.
Without objection, probable cause conference will be adjourned April 30th, 2026, 9 a.m. Bond will.
The defendant is now faced with a critical choice, waiving the right to a preliminary examination. That's not just paperwork. It's a major strategic move. The judge carefully explains the rights being surrendered, ensuring there's no confusion. The defendant agrees, but the weight of that yes carries consequences. The case is immediately elevated to circuit court, and a not guilty plea is entered. It's a moment that feels routine on the surface, but beneath it lies a high-stakes gamble that could shape the entire outcome moving forward.
Continue.
Thank you.
Are you ready on 12th yet? Or
Yes, Your Honor, of course.
court,
Sure, on the waiver. So,
court recalls the case, people of the state of Michigan versus Troy Swope.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir? Troy Swope. Mr. Swope, you're waiving your right to a preliminary examination?
There is an agreement, Your Honor, that if Mr. Swope waives exam and resolves this matter in circuit court, there will not be a charge of malicious destruction brought that is presently in the prosecutor's office.
That is correct, Your Honor.
All right. So, sir, you're waiving your right to a preliminary examination?
You have to speak up.
Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
You'll also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of an information in this matter. My client waives its reading, stands mute, asked that a not guilty plea be entered.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
June 3rd, 1:30 with Judge Conlon.
June 3rd, 2026, 1:30 for Judge Conlon.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued.
Now the courtroom energy shifts as a new case brings confusion and concern into focus. The judge zeroes in on one key issue: why the defendant refused a breath test. That unanswered question lingers heavily in the room. The defense pushes for leniency, suggesting treatment and a reduced bond, but the situation isn't that simple. There's back and forth, hesitation, and a clear sense that something isn't adding up. In the end, stricter conditions are imposed, including a GPS tether and drug testing. The judge's lingering doubt says it all. This is far from a routine decision.
Court calls the case of the people versus Rayvon Reed.
Your Honor, reading for the people.
Morning. Saxa for Rayvon Reed. Mr. Reed, state your name for the court.
Rayvon Deshaun Reed.
Why did he, when he came back off the furlough, why did he the PBT?
He didn't.
Right.
I recall that the court ordered it, and then he refused.
All right. Go on.
Your Honor, I did submit a stipulation order for release to treatment. Excuse me. I would also ask for an amendment to his bond. He has a personal bond currently, and I would ask for a nominal bond, $100, 10%, allowing him to get jail credit and still be ordered to treatment with the GPS tether.
But what am I doing with the case?
Asking for an adjournment to give him time to get into treatment and see if we can get a resolution.
I'll adjourn to April 30th, 2020, 9 a.m. I would indicate that I'll reset his bond at $5,000, 10% bond.
Your Honor, in that case, then Mr. has indicated that he does not want the bond revoked because, you'll get you. Yeah, he'll accept the bond as is, as you just ordered.
I will sign the release to treatment on a GPS unless there's some objection from the people.
No, Your Honor.
I would also indicate that prior to his release, defendants to go over and take a drug test. At community corrections. That's in regard to his release on the furlough. Still don't understand why he wouldn't take a BBT. That's a concern. Thank you.
Now we enter one of the most intense portions of the hearing, where the charges themselves raise the stakes dramatically. The defendant faces serious allegations, including aggravated stalking, and the details paint a troubling picture of repeated behavior. As the prosecution outlines threats and ongoing harassment, the tension builds. The defense attempts to soften the situation, but the judge isn't convinced. What follows is a firm and detailed set of restrictions. No contact, no weapons, no movement without permission. Then comes the hammer, a $50,000 bond. It's a clear message that the court sees this as a serious and ongoing risk.
Thank you, Your Honor.
Court calls the cases of the people versus Deion Bird.
Thank you.
I have a deed.
Good morning, Your Honor. That's the Republican Freedom behalf of people.
Your name?
Deion Bird.
Mr. Bird, you are before the court on 2 felony complaints. Ending in 0228. That alleges that on or about August 9th, 2024, location of 8790 MacArthur Boulevard, Superior Township, that you did commit the offense of stalking on an Erica Demerson Bird. You understand? Actually, aggravated stalking. Do you understand the nature of that charge, sir?
Yes.
That's a felony punishable by up to 5 years incarceration and $10,000 fine plus court costs. Probation could be ordered for any term of years not less than 5. You understand that, sir?
Yes.
Count 2 on that complaint alleges the offense of malicious telecommunications service involving a domestic relationship. You understand that charge, sir?
Yes.
Misdemeanor punishable by up to 6 months incarceration and $1,000 fine plus court costs. Understand that?
Yes.
On the other case, the case ending in 0229, that alleges that on or about August 10th, 2024, at the location, same location of 8790 MacArthur Boulevard in Superior Township, that you did that time also commit the offense of stalking or aggravated stalking. You understand that charge?
Yes.
Felony, 5 years, $10,000 fine plus court cost. probation for not less than 5 years. You understand that, sir?
Yes.
The other is also the same charge of malicious use of a telecommunications device involving a domestic relationship. Misdemeanor punishable by up to 6 months, $1,000 fine plus court costs. You understand all of that, sir?
Yes.
First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bird.
You waive for further formal reading.
Yes, we will wait for the formal reading, be standing mute as to the charges.
And then having waived formal reading, standing mute as to the charges. I'll set a probable cause conference in this matter for
April 30th.
MP. April 23rd, 2026, 9 a.m. As to bond.
Your Honor, in this case, is the person to see if the bond is an issue for from office.
I believe I am. Yes, I am.
For the record, Your Honor, we're requesting a $50,000 surety bond, as well as a GPS tether with a hot zone of 8790 MacArthur Boulevard in Pennsylvania. We are with a criminal contact, with the victim, as well as the conditions, including those that firearms and or other weapons, based on this being a domestic offense. Your Honor, in this case, defendant was texting the victim friendly messages using his mom's phone to tell the victim. Some of the threatening messages included like even if see
Yeah, so I was utilization.
walking you bitch. Gotta learn to call my name and issue mouth. Don't be home. Victim, this is a reauthorization, Your Honor. So initially the cases were dismissed. However, defendant made the decision to continue his harassment of the victim repeatedly. And so here we are again. This time the case is not just going to disappear. So with all type honor, that is our.
Your Honor, at this time, I would be requesting a personal conscience bond on my client's behalf, as indicated by APA Tanha. This is a reauthorization. These cases were already litigated. He is here purposely availing himself to the court today to handle these matters. He is not running away from these matters, as indicated. He is here standing next to me right now. He does have full-time gainful employment. I do not believe there will be issues of any no contact or no go to orders. At this time, Your Honor, based upon the fact that my client is here trying to get these matters handled on reauthorized cases, I believe a personal conscience bond would be appropriate.
Right. Well, as to the conditions of the defendant's release, I would indicate, first of all, that there is to be no use and or possession of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
You are not to leave the state of Michigan without permission of the court. I will also indicate that you are not to purchase, possess a firearm, ammunition, dangerous weapon, or anything fashioned to be a weapon. You understand that?
Yes.
You are ordered not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You understand that, sir?
Yes.
I will also indicate that you are not to have contact by any means whatsoever with Erica Jimerson Bird. You understand that?
Yes.
And when I say no contact, I mean absolutely no contact except with a civil standby. You shall not attempt to have any direct or indirect contact with that person, either through others or through yourself. You're not to do that with any electronic communication. That's including but not limited to phone, email, texting, internet, and you are not to mention that person on social media or on the internet. You understand that, sir?
Yes.
I'm also going to indicate that you are not to go to the 8790 MacArthur Boulevard. You understand that?
Yes.
Except with a civil standby. You understand that, sir?
Yes.
You are not to violate any criminal law. You are to personally appear at all court proceedings. You understand that these conditions that I've given would apply whether you're in custody or you are released. You understand that, sir?
Yes, sir.
I am going to, for a review of the bond sheet, everything, I am going to set the defendant's bond at about $50,000. as surety on each case. Defendant is ordered remanded. If defendant is released, he's to be placed upon a home confinement GPS tether. Thank you.
This final segment brings a powerful human element into the courtroom. A plea for bond reduction is made, backed by personal responsibilities and family hardship, but the court remains unmoved. Then the focus shifts to another defendant, where mental health becomes central to the discussion. The defense argues this was not just a crime, but a crisis. The prosecution, however, highlights past violence and public safety concerns. What truly stands out is the defendant's own words, raw, uncertain, and revealing a struggle to find help. The judge acknowledges it, but still holds the line, leaving the case in a tense and unresolved state.
Your name?
Cardinal Sanders.
Your Honor, and have two requests. The first request is that both matters be set for a preliminary exam. And
Is all discovery complete?
yes, Your Honor.
We do have is get that from someone
Yep.
to her. So I will get that sent to her ASAP.
Okay.
As of discovery not complete, but we do send her exam. I will.
Yeah, I don't think that would interfere with the time frame. We should have it by the exam.
Okay, you don't get an adjournment if for whatever reason it's not there. All right. Would the people have their witnesses available the 21st?
We'll do our best.
Preliminary examination will be set the 21st, 2026, 9 a.m. before Judge Garwood on both matters.
And the other request we have is my client would like me to address bond, Your Honor.
Go ahead briefly.
Okay, Your Honor, the chain of circumstances from the last bond argument is that my client is the caretaker for her uncle, Mr. Joe Robinson, who's actually in the gallery today. I've had an opportunity to speak with him. He's 82. He is having some liver issues that will require surgery. He's actually explained to me that he declined to have surgery at this time because Ms. Sanders is incarcerated. He explained to me that Ms. Sanders could live with him. We have the address here. It's local. She also has a friend of the family here, Mr. Benson, who is also here to support to ensure that she stays on the narrow. Ms. Sanders explains to me she's willing to go on a tether, and that she has been pursuing her education through Washtenaw County Community College. So we're asking that a bond reduction or a PR bond be allowed, Your Honor.
Response.
Your Honor. Bring this. Defendant has two assaulted. One involving minor issue. I would simply ask that the bond remain the same. Yeah.
It's my understanding that the children are not in the current 401 address where my client will be going to. I think that they're being looked after. There's also a neglect.
Whom?
I'm sorry,
Sister.
her sister. So she's not having any kind of direct contact with the children at this time.
Motion for bond reduction tonight. Bond will continue.
Thank you, Your Honor.
Of course, raise it after exam.
All right, thank you, Your Honor.
Court calls the case. People versus Amanda Dickinson.
Your Honor, Raymond Cook for the people.
All right, thank you.
Finally located him.
That's fine.
I sent a bunch of people out to track him down. Mr. Johnson, can you state your appearance, sir?
Good morning, Mayor. Please, Honorable Court. Kareem Johnson on behalf of Ms. Tippins.
Your name again, man.
Andrea Tippins.
All right, what are we doing on this?
Yeah, I'm humbly asking this court for an adjournment. I have gotten information and discovered from the prosecutor's office. I need to talk to Ms. Tippins about some things, but I would like to address her bond as well, Your Honor.
All right. Will a couple of weeks give you enough time?
Yes, Your Honor. I was hoping the court could give me the 30th.
30th? Okay. I'll do that. Probable cause April 30th, 2026. 9 a.m. Okay, yes, that's the bond.
Yeah, my client is indigent. These charges are serious. However, I believe that a mental health episode may have been what was at root of this issue. I don't know what all the court saw in the request for warrant, but she was, she left the bus. She was arrested without incident. This happened on the bus. I don't believe she made contact with anybody on the bus, especially to make contact with anybody on the bus with a weapon. So we'd ask the court to consider a nominal bond, considering her indigency, the fact that mental health may have played a role in this, and the fact that I don't think that she's a flight risk, Your Honor.
Response from the people.
John, I would agree with the characterization. There's a pretty significant mental health episode, but I do have concerns for public safety. This does not appear to be the first run-in with the law, especially in an assaultive matter. I am seeing previous convictions for felonious assault as well as assault and battery. Luckily, no one in this instance was harmed. If there were some way the defendant could get treatment either in custody or with a release to treatment, I think that would prove incredibly helpful for this defendant as well as resolution of this case. But I do have concerns for public safety, given the nature of this offense, being that the defendant essentially tried to take the necklace off of a passerby on a bus with a knife. And I'll leave it at that.
Do you receive services from CMH?
No, see, cause I don't get any service around, cause I don't know where to go to for any mental service.
Got it. Okay, so you're just not sure where to go.
Not sure. I seen some places, but I wanted to stop by, but I just thought that there was for teenagers or children only. I'm 42, and basically,
You're young.
yeah, I'm just keeping myself together, not trying to prove the fact that I can act tough, but I don't want to do anything really stupid like take a life or a little piece of jewelry. I can go out and buy myself.
Okay, listen. I'll put it out to the 30th, but if somehow we can get her, I think she wants services.
Yeah, I want refer
Out where to go. Okay, so if counsel can try, I'll deny the request. I'll continue her bond at this time. But if counsel can get together and try to figure out how to get her hooked into some services, I would certainly consider some alternative in terms of incarceration, but some type of release. We just got to get her set up.
Yes, Your Honor.
Okay. All right. Thank you.
Thank you.